Okay, wrote this Substack that kind of went viral. I want to talk about it. It's about founders stop reimbursing your VC's legal fees. And it kind of all started when I remember this terrible feeling after wiring $32,432 to a law firm that didn't even represent me. It represented the venture capitalists who were negotiating against me. And everything about that just felt wrong. Ramen eating founders should not be footing the legal bills for billionaire venture capitalists. Yet it is the industry default to do that today. The most outrageous term sheet item is also the most common. Almost every VC asks their founders to reimburse their legal fees. I've personally raised more than 15 price rounds in my career, and I've paid my VC's legal fees every single time. Any VC that does this is actually the opposite of founder friendly. VCs should pay their own legal fees. And those legal fees they aren't cheap. It's not uncommon for venture capitalists to ask a founder to pay for $50,000, even $100,000 reimbursement on a $5 million round. I've seen worst case scenario, even like $300,000 reimbursements. It's kind of like hiring a good software engineer for 6 months, and that's gone to the lawyers in a single wire. It's a charge to the companies of 1 to 2% of the round right off the bat, and it's just outrageous. These fees are very dilutive to a company, and they actively incentivize lawyers on both sides to rack up billable hours. Most of these deals have legal fees cap, but guess what happens when you set the cap? The lawyers work just super hard to meet it. Parkinson's law says work expands so as to fill the time available for completion. You will never, ever get a bill from the opposing counsel's lawyers that is less than 90% of the legal fee cap, maybe even less than 98% of the legal fee cap. The VC lawyers have no one watching their costs, and every $2,000 they bill is usually at least a day in delay in closing. This is also a double taxing of shareholders and LPs. This practice isn't just unfriendly to founders, it's also unfriendly to LPs. By having one endowment shelled out over $3 million last year for quote-unquote deal expenses that they never approved. By having portfolio companies pay for a VC's legal expense, the VC is essentially backdooring another expense that LP will never see or audit. This is because VCs are billing the legal fees to the fund without explicitly telling their VCs about the billing practice, and that is just wrong. Most people don't realize that venture capitalists split their expenses between the management company, which collects that 2% annual fee, and direct charges to LPs in their funds. Costs like deal diligence, fund administration, banking, annual meetings, and even travel are sometimes passed through to the LPs. Meanwhile, that 2% management fee is carefully protected to fund those large general partner salaries. So, of course, why not just pass those legal fees to the LP? Well, VCs are required to report fees passed to the LPs, and those fees face a lot of scrutiny because they are additional fees that come right out of the LP pockets, and they must go through a deep audit. So the VCs elect to backdoor the fees, and honestly, it's just kind of unseemly, and it may not even be legal. Most VCs overbill their fund for things that they shouldn't and overtly hurt their LPs, but at least most of those expenses are explicitly categorized, and the LPs can see them, and they could debate them and talk to their GPs about them. These hidden fees to the fund are against the spirit of being a limited partner. Expensing a VC's legal fees takes advantage of both the company's shareholders and the VC shareholders. It's doubly bad. It's both founder unfriendly and VC unfriendly. The reason this bad practice exists, really the only logical answer is because it can. No one fights back. Every lawyer just says, well, this is how it's always been done. 98%, maybe even 99% of VCs do this, but not every venture capitalist does this. When I did my first VC deals, I reflexively asked founders to reimburse my legal fees too, but quickly ended that practice because it's extremely unfriendly to both the founders and the LPs. Plural, which is a highly regarded European VC, doesn't do this. Flex Capital, where I work, doesn't do this. Relentless doesn't do this. Y Combinator doesn't do this. All have an explicit policy of not asking their portfolio companies to cover legal fees. These are the good guys. If you know of other VCs that are truly founder friendly, please comment or email me, and I'll add them here so we can celebrate those people. And look, founders, everything is negotiable. So start with the ask. Let's line item those VCs to zero, and the VC can pay their own. And maybe even go further, add like a delay penalty clause for every extra week caused by the VC's a delay of extra VC's counsel. The VC reimburses the company another $5,000 or something. Now, VCs, Y Combinator already populates the SAFE, which has been great and usually does not need any legal fees because it's super simple. YC could go one step further and specifically tell VCs that it will discourage its founders from working with investors that push these founder-unfriendly terms and priced rounds. We could also make just like easier rounds so that it just doesn't need to be this complicated. Most of this stuff is negotiated in the term sheet. Going from term sheet to close should honestly be much, much, much easier. It just shouldn't be so hard. Big LPs could also put pressure on venture capitalists to change this practice. These limited partners should require VCs to report any backdoor fees to their funds. We really need to change this bad practice once and for all. Thank you. Again, my name is Auren Hoffman, and this has been a great Substack. Hope you read it. Thank you again.